Thank you, Council. On behalf of Vancouver Rape Relief and Women's Shelter, of whom I am counsel, I oppose the staff recommendation. I'm here to address the so-called Nixon decision and the consequences of that decision. And there have been some misconceptions that I've heard today about it, and I intend to address that. It is Vancouver Rape Relief and Women's Shelter's position that neither its existence nor its work breaches the BC Human Rights Code. To the contrary, it is one of the few organisations in BC to have a positive ruling in that regard from the highest court in BC. I'll spend a moment talking about the decision. In 1995, Kimberly Nixon, a transgender woman, filed a human rights complaint against Vancouver Rape Relief and Women's Shelter because it excluded Ms. Nixon from its volunteer training programme. The complaint was grounded in Section 8 of the Human Rights Code, which applies to services, and Section 13, which applies to employment. With respect to Section 8, Ms. Nixon alleged that the volunteer training programme, an educational programme, was and is a service that Vancouver Rape Relief and Women's Shelter generally makes available to the public. This was not, therefore, a case solely about membership. The Court of Appeal upheld that finding that the volunteer training programme is a service within the meaning of Section 8, but expressed reservation that the programme could be employment. Factors about why the training programme is a service included, first of all, that Vancouver Rape Relief advertised publicly for its volunteers and offered to provide training. That second, the training received at Rape Relief would be useful elsewhere in the feminist movement. Not everyone who undertook the training went on to volunteer or work with Rape Relief. And also that Rape Relief offers a number of different services to the public, including a 24-hour crisis line, a transition house and training programme, and that the training programme was a necessary adjunct of its other services. The BC Supreme Court and the Court of Appeal both held that Vancouver Rape Relief and Women's Shelter is an equality-seeking organisation and as such is protected and entitled to the benefits of Section 41 of the Human Rights Code. And Section 41 provides that if a charitable organisation or corporation that is not operated for profit has as a primary purpose the promotion of the interests and welfare of an identifiable group or class of persons characterised by a common sex, in this case, that organisation must not be considered to be contravening this code because it is granting a preference to members of that identifiable group or class of persons. As was noted by the Court of Appeal, Section 41 protects certain non-profit organisations, such as an equality-seeking organisation, as Rape Relief describes itself, from liability. The Court of Appeal at paragraph 51 held that Section 41 confers and protects rights and protects the right to associate. And because Rape Relief is protected by Section 41, it was legally entitled to exclude Ms. Nixon from its service, and to do so was not unlawful discrimination. The Court of Appeal agreed that Vancouver Rape Relief and Women's Shelter standard had been adopted in good faith and was rationally connected to the primary purpose of providing services to victims of rape and being an educational force for progressive changes in attitudes, laws, institutional procedures, and to work for the prevention of rape. In 2007, the Supreme Court of Canada refused Ms. Nixon leave to appeal to the Court of Appeal decision. I will address the misconceptions, and there are four that I will address. First, the first misconception is that this decision is only about membership in a private organisation. The BC Human Rights Tribunal does not have jurisdiction over membership in private organisations. If this case was about that, the hearing would never have taken place in the first place. The second misconception is that this decision is not about services. This decision directly addresses services provided by Vancouver Rape Relief and Women's Shelter to the public. Ms. Nixon's complaint alleged that the training programme was a service, and the Court of Appeal agreed. This case was about services. The third misconception is that the amendment to the Human Rights Code, adding gender identity as a separate ground, changes the decision. Now, since 1999, transgender people have been protected under human rights legislation under the ground of sex. In a decision that preceded the human rights hearing in the Nixon case, the BC Supreme Court specifically found that Ms. Nixon is medically and legally female and therefore entitled to protection under the Human Rights Code. The decision itself recognises that Ms. Nixon's transsexualism, as it was described then, was protected under the Human Rights Code. So rather than create a new ground of protection, the addition of gender identity merely explicitly reflects the protections already existed at the time. The fourth misconception, the final one, is that sex-based protections have superseded protections by gender identity. The decision.
I'm afraid that is your time, but you do have speakers starting with questions. Sorry, starting with Councillor Hardwick.
Thank you. You were going into area that I was interested in trying to understand better, the difference between sexual preference and gender identification, and how these are treated in the between the Human Rights Code and the Supreme Court, and generally how these are being aligned with our own policies here at the City of Vancouver.
Well, I'll explain it this way. In the Dixon case, of course, the Nixon case, obviously the ground of gender identity hadn't been there. But when it was added, it was explicitly referencing the fact that transgender people have been protected since 1999 under the ground of sex. The interplay, if you like, between sex and gender identity has not been decided by any court, and as far as I'm aware, not in any across the country, hasn't decided it. So therefore, the protection that rape relief has on the ground of sex is still in place and has never been overruled. It's still good law, the Nixon decision. Gender identity is, as I understand it, hasn't been defined in the legislation. Different organisations across the country have attempted to identify or to define it as a matter of policy reasons, but it hasn't actually been defined by any other courts yet. I can go on and tell you what some organisations have said gender means or gender identity means. In the Ontario Human Rights Commission has identified gender as being the expectations, behaviours and stereotypes placed upon people according to the sex that they were born with. So a gender identity in that regard means the extent to which a person internally believes that they are subjected to the behaviours, expectations, stereotypes that have been assigned to that particular sex or not.
Just going back to the alignment between the BC Human Rights Code, the Court of Appeal decision that you described, and the policies of the city. Have you looked at the two in counterpoint?
I have not. I mean, I have noticed that your policy doesn't include the ground of sex as a protected characteristic. I did actually point that out to Council last year when I wrote to Council. So your policies don't include that as a particular ground, and so and that can be important, I would say, from the perspective of your exception, because you do have an exception that is intended to assist equality-seeking groups. But if you don't include sex as a protected characteristic, then how can you have an exception for groups that are that formed and based and provide services on the protection of a common sex?
Thank you very much.
Thanks so much. Councillor Hardwick, that's your questions. Councillor Dominato, questions for the speaker.
Thanks, Madam Chair, and thanks for being here. I was trying to review your letter again because we only just received it either late yesterday or first thing this morning. I'm just curious around, because we're really today what we're looking at is the recommended staff recommendations around the grants, and that's based on eligibility criteria. So we're not looking at organizations in terms of the BC Human Rights Code. And so I'm just curious, and maybe this speaks to Councillor Hardwick's question, but I'm not clear. Like, were you suggesting in your last answer that our eligibility criteria are lacking in some way? I'm just trying to get some clarity on that.
Yes.
Is that what you were trying to say?
Yes. It is lacking. It lacks the ground of sex as a protected characteristic. So therefore, your exceptions for equality-seeking groups that are formed on the basis of a common sex cannot fall within that exception. So it cannot be a group that is formed around a common sex to provide services for that common sex that are protected by the Human Rights Code would have difficulty meeting your eligibility criteria. I did raise that in a letter that I sent to Council a year ago, which you may have read.
Yes. No, thank you for that. Sorry, I was just reviewing our report here as well as your letter. I'm not sure if there's anyone else who has questions. I have probably another, but, oh, indeed, I see Councillor Bly's on, so I may come back on. Thanks.
Thank you. Councillor Bly.
Thanks very much, and thanks very much for being here. So just to back up a little bit, because this is not, although I appreciate a lot of the context you provided around your experience in the legalities around historical case law in this discussion. It was also something, and I looked into the C16 because we had heard about it in one of our letters. And I wonder if you can confirm or interpret this in any way, that the case that you refer to states the case ultimately made its way to the British Columbia Court of Appeal, which held that there had been discrimination, point one. Second, but that under the circumstances, the society was exempted under Section 41. So I just want to point out that if we drill right down into the legalities, I appreciate where you're coming from. However, this is not a legal, we're not in that discussion right now. What we're talking about is more around discrimination. So I'm just wondering if you can, and trans inclusivity. And so, and would it be fair to say, second to that, and I'll let you answer, would sex be implicit in identifying someone's gender to address the eligibility criteria that you're concerned about?
Let me address the first point, because I don't think I understand your second point, but let me address your first point. Discrimination under the Human Rights Code has two aspects to it. First of all, in any case of any discrimination, to find whether there was discrimination or not, there's a two-part test. And the first is that the complainant has to show that there's prima facie discrimination. That means that there's been a difference or adverse treatment. And then the onus, if you like, switches to the respondent to show how that is not actually discrimination that's unlawful under the code. So in the Nixon case, what the court found was, yes, there was prima facie discrimination at the second level, at the first level, which then flipped it over to Vancouver Rape Relief to show that it wasn't unlawful discrimination and wasn't a violation of the code. And at that point, Vancouver Rape Relief was successful in establishing that it was an equality-seeking group, and maintaining a preference within that was not unlawful discrimination under the code. So discrimination, if you're being precise and using it in a legal term, no, there was no discrimination. There was no unlawful discrimination, which is what I've said in my letter. Now, the second one, I think I'm going to need your assistance to help me understand what your point is.
I think I'm going to be out of time, and I've been pointed out by a fellow councillor not to drift over 3 minutes, so I'll have to leave it there. Thanks.
Thank you.
Thank you. There are no other questions for you.
Thank you.
Next speaker is speaker 40, Danielle Cormier.